Agora, se quiserem fazer o favor de dirigir perguntas ao painel, nomeadamente aos dois oradores que precederam, seria a altura adequada para isso. If you can ask any questions about any of the interventions that you have just heard, please go ahead.
Good afternoon again. Thank you for your presentations. They were an overview of your systems, legal systems, and the position of prosecution. What I would like to ask first is something related with public expectations. That was the theme of the first intervention. How can organization of public prosecution service can meet public expectations? I think that that word and that expression is related with accountability of prosecution service. I mean, public expectations nowadays has a lot to do with public perceptions. And public perceptions are often instrumentalized by a lot of social and political forces. We even have fake news. So, how should the public prosecution service deal and have real accountability in this kind of context that for me is a bit pathological, socially pathological? And how can he gather the public confidence given that accountability in such a context that is adversarial for public prosecution, for public confidence in justice, and for real accountability? I mean, how to deal first and in the end with media. That is the second part, or I mean, a branch of the question. How should, for being accountable in your countries, you can describe that if you can, is the relation of public prosecution with media? Do you think for being more accountable, public prosecution should lead the process of information or react to that process? I don't know how it is in your country, but I would like you to make some comments, if you want, if you please, to this, to make a collective reflection about this topic. The other question is about efficacy of public prosecution. This is the word of the moment. Efficacy of services, new public management. So we have efficacy as an economic rule that is brought to justice, as if it could be possible to have economical principles in different spheres, as Michael Walzer said in his book, Spheres of Justice. We cannot use principles in economy and put them critically in other fields like justice. So it's not coherent and it's not methodologically right. But anyway, we have efficacy in every kind of documents related to public policies that has something to do with justice or other areas. So what does that mean in your country? Have you also have that kind of imposition, as I like to call it, a ghost rule, a ghost principle of the activity of public prosecution, of the relation with between hierarchy and public prosecutors and prosecutors? There's efficacy as the cornerstone of everything. Does efficacy mean, in the light of the European Court of Human Rights and European Council of Prosecutors, means what? Means making justice? Means, for instance, that the reasonable time of getting done with the process and with the files, is that efficacy or does that mean celerity? I think I would like you to clarify and contribute to this discussion, because efficacy is now being understood, in my point of view, in the wrong way. Being efficacy in justice is making justice in reasonable time, not in celerity, precipitation, immediativity, etc. So I would like you also to reflect. And regarding the first question, just to point out one aspect, that is accountability makes a lot of sense in systems where we have prosecutors elected, like American, for instance. But is it the same in systems like civil systems, European systems, where we don't have prosecutors elected? So these are my topics of discussion. Thank you.
Hey, thank you for your questions. These are really difficult and important issues that we have to deal with in every country. So I will begin with the first question, meeting the public expectations. As every one of you have already experienced, I presume, and believe that all the time when you talk about the crimes, the general public wants to see blood. They don't want to see effective criminal proceeding. Everything they want is payback. They want to see blood, and etc. So it's very important to give open and trustworthy information out of prosecutor's office. In Estonia, we as prosecutors are responsible for sharing information about criminal procedures as well. We are the ones who decide what information can be published about the specific investigation, and we can give permission to publish any kind of specific details of investigations to media. And what is our approach in Estonian Public Prosecutor's Office is that we try to be very honest with media, we try to be open, but in the other hand, we want to not only give information, but to explain what we are doing and what is the purpose of our deeds. That we are trying to we are always explaining that we are not only investigating a crime, we are not only prosecuting a crime, but there is an impact of the investigation that we are leading and the impact on the fight against the crime in specific areas. Take question of driving a car under alcoholic intoxication, for example. This is a huge issue in Estonia. General public wants to see all the people who are driving car under influence of alcohol in the prison, and we as prosecutors have to do a lot of explaining, but it has been working because we are saying that we don't want to punish people, we want to make the difference. We want to make an impact when we influence the people, and influencing people is not only adopting any kind of punishment, but sending them to trainings like my colleague told you, sending them to social programs, and this is the approach we try to use in every case. So maybe my colleague would like to answer the second question, and then I'll interfere with the discussion once again.
I wanted to add something to your response to the first question, because I strongly believe that it's, of course, as a public prosecution service, you should be transparent, and it's your task to show society that it's not in all the cases that there should be blood, but there are always also other possibilities. But I strongly believe also that it's the task of every prosecutor to speak normal language in court, because that's also a way of managing the expectations of the public. We are lawyers, but most of the victims aren't. And we used to talk in a specific lawyer way, which doesn't always respond to what the people want to hear. So that's why I'm always very pleased when I have victims, an appointment with victims. It also gives me the possibility to manage their expectations and to be more informal and tell them about the procedure. So it's not only up to the office itself, but I also strongly believe that's a role for every prosecutor individually. And I must say, perhaps it's my English, but I find it quite difficult to answer the second question, to be honest.
As I understood, the second question was about the efficiency of the prosecutor's office, and is it economically efficient to prosecute crimes and investigate all kind of crimes? So it's very difficult to answer, because investigating crimes and doing it in the frames of criminal procedure is very costly, but my opinion on the topic is the same like for the first question, that you have to explain your goals and strategies very openly, very publicly, and you have to explain the general public that although you may seem to be wasting money, there is a larger impact whenever you investigate any kind of crime. It may seem that you investigate one corruption case, you waste a lot of taxpayers' money for the court sessions, for the working hours of the police investigators and prosecutors, but on the other hand, you know that whenever you investigate something like that, 10 more people maybe stop their crimes, and this is very cost efficient actually. The same goes for economic crimes, drug crimes. We could investigate drug crimes like we do. We still have a drug selling problem, but I don't know what would happen if we didn't do it. Maybe our situation would be like in Afghanistan, where they have every 10th male is heroin addict. I don't know. There is always a second story involved when you don't do anything, and we don't know the answer to the second question. Thanks.
Well, let's try to address all the three questions altogether to see whether I can give something added value to those that already preceded me. Well, as far as I can see, as far as the Consultative Council for European Prosecutors sees the Public Prosecution Service, it is a public service. And it has a responsibility for end users of the justice criminal system, or the justice system as a whole. We are one of the stakeholders of this system, like the judges, the lawyers, and all the participants in the proceedings. In criminal matters, the defendants, the victims, the witnesses, the experts, and so on. So the fact that the public opinion is concerned about the public service as the administration of justice will lead us to think that we have to rethink the way we proceed in order to find better and more clever answers to the expectations of the public. So in a sense, I would say that we should not react to reality, but should try to influence the reality. And of course, when you decide to establish goals and priorities for your public prosecution office, you're making choices. And these choices have impact on citizens' lives in your public prosecution service as well. So I would say that as a matter of fact and as a matter of intelligence, it would be good for public prosecution to explain the priorities they choose, how they manage to have them work in practice, and what is the impact of those priorities and goals in their activities. In this way, they get leverage to discuss, for instance, asking for new resources. If they can explain that by conducting a particular type of activities, they manage to work in a more clever way and with better results, it's probable that Parliament or government will be much more sensitive to give further assets to the Public Prosecution Office to function. As far as relation to the media is concerned, the fact is that nowadays, as we live in an information society, we cannot escape public scrutiny. Public scrutiny means public opinion and also media opinion. And if we just react to the intervention of the media, or go after the reactions of the public, we are bound to lose the war because we're not influencing it. So I would say that probably the most wise thing, as it happens in both countries that we have seen so far, is that the fact that as you give by your own initiative particular information on the conduct of particular sensitive cases, you are shaping the information that you want to give, but you are not overstepping this and establishing limits not to go beyond this. And you can be responsible, for instance, for victims' rights, for defendants' rights, but also with public expectations as well. Of course, there will be cases in which public opinion will not be in accordance with the goals that you have set about the information that you have imparted. That's part of the risk. But nevertheless, at least you are being proactive and not just reacting. Finally, as for accountability, well, accountability is just a consequence of being public servants, although a particular kind of public servants. In most of the countries in Europe, probably actually in nowadays, public prosecution is independent. But the fact that it is independent also implies that you have responsibility before some stakeholders, the public, Parliament, and we have to explain, at least when we produce an yearly report about our activity, what we have managed to do and how we have done it. It's part of any kind of transparent way of acting of any public service. I don't see that the fact that we are elected or not will necessarily have to make an influence on this decision by the public prosecution itself to work as transparent as possible. Because normally justice system is by itself a closed system for the general public. We have a different language. We have some kind of procedure that is very difficult for people outside the courts to understand. And so if you don't make an effort to explain what we are doing and why we are doing it, then we're probably going to miss the possibility of explaining how hard we are working in order to deliver a better justice within the courts, for instance. And in a certain way, we may, by doing this, we may be assuring independence for courts, because prosecutors are one of the major assets for ensuring independence of courts. I don't know if I've answered all your questions, at least I've tried. Thank you.
Allow me to raise another question, and that's about an aspect that was mentioned by Mr. Dona when he mentioned the fast lane prosecution in the Netherlands for minor cases. My question is for you both, not only for Mr. Dona, but doesn't a speedy prosecution, is that not the enemy of fair prosecutions? Is speedy prosecution the enemy of fair prosecution? That interested me because speed can also mean less care. And I would like to have your comments on that. Thank you very much.
In Estonia, speedy prosecutions are possible as well. We have the principle of opportunity, like my colleague told. We have the speedy prosecution option, but both options don't mean that they are enemies of the fair trial, because these options are used only with minor cases. First of all, then the speedy prosecution means that still the prosecutor, the judge and even the lawyer are involved in the case, and the speedy prosecution doesn't mean that you don't have to gather evidence. You just do it very quickly in Estonia. Maybe you are dealing with shoplifting case, maybe you're dealing with driving under influence case, but still you have to use the same laws, the same standards to gather evidence, and I presume that this is the fact that keeps the rights of the suspect or the accused one in the right place. Thank you.
Yes, I think that speed and fairness are a very subtle balance. And of course, speed is in the interest of all the participants, as well for the public prosecution service as the defendant. But it should never mean that it's not been thought over well and that the quality isn't the same. But when in the old days the police would file a report to the proper prosecution service, we would put it on a pile, and after a few months we would read it and take a decision. There's a balance, and sometimes when the police do their work properly, and there's a, like I told the ZSM body, where really people ensure that everything is done on the correct way, and that all the information we need to give a fair decision, then it's a blessing to be able to give society a response in these quite short term. But it's also one of the jobs, I think, of the prosecutor to guard that it's only done when the cases are clear, and it's never should be the case that it's less quality than without the ZSM approach.
Thank you. If I might just add something to that, I would say that it's probably in those circumstances where the figure of the public prosecutor will be a major asset for the system, because there might be a risk of fair trial violation, but the fact that the public prosecutor has to obey the law and obey strict ethical rules imposed on him or her to be certain that the speedy trial does not infringe on fair trial principles. And I recall that back in the 80s, when studying an American information system in courts in the Washington, D.C., one of the conclusions they have managed to do after having 3 to 4 years of criminal cases in an informatics system was that around 70% of the cases were caused by 3 to 5% of defendants. So if you manage to tackle swiftly those that are infringing the most part of the crimes, even if they are speedy ones, and the sense of insecurity of people is not necessarily related to grave crimes, but normally with shoplifting or something that happens in the community. If you manage to speedily deal with these type of offenses, then the sense of security in the community might increase. And of course the confidence in courts will also increase. So I would say that is a possibility of working in a more clever way, and a certain way to meet public expectations